appeal in the matter of the Good Dog Project and the Secretary of State for Health and Social Care and another.
Yes, Mr.
Good morning, my lords, my lady. In this appeal, I appear with Mr. Paynes for the appellant, and Mr. Ewan West and Mr. Jonathan Lewis appear for the respondent. In terms of the papers which I hope the court will have, you should have a core bundle and a supplementary bundle, and an authorities bundle in one volume, I believe.
Yes.
I will be using an electronic version of the authorities, but I'll give the tab numbers when I go to a case. You should also have two additional bits of authority from the claimant on your bench, which I will refer to in brief in my submissions, Regulation 50 and
yes.
the Barrow case. And you should have skeleton arguments from both parties.
We do. If that's the housekeeping, is it?
That's the housekeeping.
Well, then we got one bit of our own. Because one of the members of the court has a lunchtime work commitment, we would like to rise at 10 to 1, take an extended lunch and sit at 10 past 2. That shouldn't create any difficulties, particularly since we've now lost 3:10.
Yes. This, as the court will know, is an appeal against the order of Mrs. Justice O'Farrell of the 16th of July 2021, which you have on page 47 of the core bundle, whereby she held in summary that the claim form in these proceedings had not been validly served, and that the claim form and therefore the proceedings should be set aside. I will come to the detail of the chronology shortly, but by way of introduction, there were three relevant events before the court and which had to be considered by her ladyship, and she made findings in favour of the respondent in respect of each of those three events. The first event was on the 27th of April 2021, where the claimant's solicitors served an unsealed copy of the claim form by email to the addresses which had been specified by the defendant for email service. The judge held that that was not a procedural irregularity which could be corrected pursuant to 3.10 because it had occurred before the proceedings had commenced. The second event was the following day, on the 28th of April 2021. The claimant's solicitors served a sealed copy of the claim form by email to some, but not all, of the email addresses which had been specified for service by the defendant.
No, surely not. Only one had been specified for service.
Well, my lord, I'll show you the correspondence in a moment, but there was a request by the defendant to serve to new proceedings, which are obviously the primary address, and then to also send any new proceedings to the case holders. I'll show you that in due.
Well, that's right. Well, all right, I suppose we better look at it. But just so that I had never understood there to be any suggestion that authorised service on the case holders. I thought that what the correspondence made clear was that there should be service on the specified address copied to the case holders. If I've got that wrong, you'll show me shortly. But
well, that's we'll see the terms of the letter in a moment. But yeah. I accept, of course, the key address specified for service is new proceedings. But in terms of where the defendant told the claimant that it wished the proceedings to be sent. It wished them to be sent to new proceedings and the three case holders. And what the claimant solicitors did on the 28th of April was to send the sealed claim form to the three case holders, but not to new proceedings. And the judge held that there was no good reason, as required by CPR 6.15, to validate that alternative method of service which departed from that which had been specified by the defendant. The third event was on the 6th of May 2021, one day after the 7-day time limit for service of the claim form had expired, which was on the 5th of May. The claimant's solicitors, having been alerted on the 6th of May by the defendant to the earlier defect in service, served the sealed claim form by email to each of the addresses which had been specified by the defendant, including the new proceedings address. And the judge declined to grant the one-day extension of time for service which was sought pursuant to CPR 3.1. The appellant sought permission to appeal to challenge each of those three findings, and grounds 1, 2 and 3 correspond to those three events as I have set them out. Permission was granted by Justice Coulson on the 27th of August 2021, page 81 of the core bundle. And then, as you know, on the 13th of January 2022, the Court of Appeal handed down judgment in the Ideal Shopping case, which had been referred to at first instance, but in a different context. The effect, and I'll come back to this at the end of my submission, but the effect we accept is to prevent the appellant from relying upon 310, at least in this court. But I'll need to say a little bit more about ground 1 and Ideal at the very end of my submissions.
Sorry, you perhaps picked up, Mr. Croppell. It's not my normal court. The chair is somewhat uncomfortable for me. I think, can you just stop for a second while I see if I can adjust it? If I can't, I'll put up with it. But I don't want you to be talking while I'm fiddling with it. I think it's... No, I think it's obviously too sophisticated for me to be able to adjust you. Don't worry, it's not a major discomfort. I will put up with it.
Yeah, thank you. So my submissions will focus on grounds 2, that's the 6.15 ground, and ground 3, extension of time under 3.1. Our submission in overall summary is that the judge was wrong to bring an end to a judicial review claim of potentially significant public interest on account of an error in achieving service and a delay in achieving effective service, which could not have been any more technical nor any less substantive in its effect on the defendant. With that introduction, my submissions will now be structured in 6 parts. Firstly, I will say something about the underlying claim. Secondly, the chronology of relevant events. Thirdly, some relevant provisions of the CPR. Fourthly, ground 2. Fifthly, ground 3. And sixthly, briefly, ground 1. The underlying claim is summarised at paragraph 6 onwards of our skeleton argument.
Is it implicit in that you are not going to deal with the respondent's notice, or are you?
I will deal briefly with the respondent's notice argument under my ground 3.
Yeah. It's really up to you. I think if you know what you want to say about it, I think it would probably help us to know from the start.
Yes.
But if there are bits which you want to hear how it's put, you obviously can hold your fire to reply. But up to you.
Yeah, I've formulated the 2 sentences that I need to say.
Okay, we'll wait and hear what they are. That's fine. I just wanted to know how you've chosen to deal with it.
So I shall refer to it briefly. The underlying claim then, our skeleton paragraph 6 onwards,
Can I just ask a point of information, which is my lack of understanding? The amended statement of facts and grounds in the supplementary bundle addressed the two contracts, and from time to time you refer to a contract for the masks, which is earlier, and then the respiratory machine contract. There's an inconsistency whether the date of the respiratory contract, by the way, is the 4th or 7th of July. It would be helpful just to have that clarified. But is there an ongoing, untainted, separate claim in relation to the masks contract that survives whatever the outcome of this appeal, or have I misunderstood?
The claim as issued concerned one contract for face masks.
This claim.
As issued, it concerned one contract for face masks from July of 20.
I thought that was the respiratory contract.
They're called respirators, but they are FFP3 face masks.
Right. So that's the face mask contract. We can see the claim form at tab 8, and it's the relevant contract notice. Well, the contract. Yeah. Yes. Okay. So I understood. So that was the July 2020 contract.
Yes.
Yeah.
So that was the claim as issued. Further, subsequent to the claim being issued, further documents came to the attention of my clients concerning...
So sorry, I'm behind now. Two contracts are referred to, IIR and FFP, or FFP3. The first one was FFP3, was it?
So the one which was in the original claim was the FFP3s.
Yeah, thank you. And you were about to say something then happened.
Subsequent to the issue of the claim, further documents came to the attention of my clients concerning the award of an earlier contract for face masks. It's a different type of mask, the type 2R.
Right.
And one of the changes to the claim in the amended statement of facts and grounds was to introduce reference to the earlier contract. My client had received information about the involvement of the Home Secretary in securing the earlier contract for the same company. So the original claim is one contract. The amended claim, and I should say we don't yet have permission to amend. That all got put to one side. But the proposed amended statement of facts and grounds concerns two contracts for masks.
Okay, but sorry. I'm afraid I've tried to focus on the legal issues, and I hadn't perhaps given sufficient attention to this. The claim form that was sent, both unsealed on the 27th and sealed on the 28th, to the wrong address, did that attach a statement of facts and grounds?
It attached a statement of facts and attached brief grounds, in both cases incorporating by reference content of the pre-action letter. So
yes, I see. But now that is the only claim which has ever been formally before the court, then, isn't it?
Yes.
Yes.
So why are we hearing about the amendment?
Well,
no, I know, but why?
Well,
is it,
so
Why do
you mention it?
Why do I mention it? Because, as we'll see from the chronology when I come to it, the claim had to be issued on a protective basis before we had the information which we required to formulate it as we would have wished. So, as we'll see, because of the very tight 30-day time limit, half of which was taken up by the defendant responding, and us only receiving the interested parties' pre-action response on on the day before the time notice expired. We had to file the claim on a protected basis. Time was about to run out. It didn't.
Well, that's very interesting. But so what? Well, we are concerned with whether there should have been a validation of the defective service or an extension of time for the proceedings that were in fact served. Those only relate to the FFP3 contract. End of story.
Well, not quite end of story.
Why not? I'm not understanding.
Because we then made an amendment. Sorry, made an application to amend the statute.
But in proceedings which had by then, or what? This was while the application before Mr. Justice O'Farrell was still pending. But in proceedings which retrospectively
She mentions it in her judgment.
Yes.
Yeah.
So, the reason why the content of the claim is important is that it comes into various of the factors, including the public interest.
So your public interest claim is more weighty if it refers to two contracts than one.
Well, the public interest argument is properly put with reference to what we would expect the claim will be about if it's allowed to go ahead.
Well, I wonder.
And it will be about two contracts.
Okay, I see. Okay, but anyway, I see how it fits in.
But, my Lord, I don't think it makes a huge amount of difference whether it's two contracts rather than one to the issues that
Right.
When did the 30 days expire in relation to the 2R contract?
I'm sorry, my Lord, I missed the start.
When did the 30 days expire in relation to the other contract?
So I'll check the exact date, but what 30 days runs from the date of knowledge.
Or constructive knowledge.
Or
So
constructive
it could be quite a complicated exercise to work out what the 30 days is.
But what Mr. Morm explains in his witness statement, the documents which gave rise to the grounds for claim, which disclosed the Home Secretary's involvement in the award of the contract, only came to the claimant's attention after the claim had been issued.
That's good.
And that would be when the 30 days would run from.
But you could have issued a fresh claim form.
We could have issued a fresh claim form in relation to that contract, but since we had proceedings on foot about a different contract, but concerning the same economic operator, the same government official, the same government minister, it seemed.
When the Treasury Solicitor wrote to you on the 6th of May and said, query whether there's been valid service, you could at that point have protected your position in relation to the other contract. But you did, is that right?
I think that is right, my Lord.
But you didn't. And so isn't that why it's now a completely irrelevant matter for us? Because it stands or falls on this argument, doesn't it?
Well, my Lord, there were two ways in which we could have pursued a claim in relation to the second contract. One by, as you say, issuing a new claim form. The other by seeking an amendment to the existing claim. Now,
Might have been more. I'm not criticising anyone, but surely it might have been more prudent to issue fresh proceedings, because depending obviously on problems about data knowledge and so on, you might have been in time for that if you'd done it promptly.
Well, my Lord, maybe. But I need to double check the chronology, but I'll yes, provisionally we could have issued a new claim rather than rely upon an application to amend. But the point remains, the point I started with, that my submissions about the public interest, about prejudice and so forth, involve focusing on what the claim is likely to be about if it gets over the hurdle which it has to get over before this court.
Well, that depends on whether permission to amend is due.
It does.
You may say, oh, it's obvious it would be. If you've got I don't know. Maybe, maybe not. But it's not. I mean, it's unhappy for us to have to take a former view on those sorts of questions. It's more straightforward for us to do it on the claim that actually you're presented with.
Well, my Lord, it would be surprising if your conclusion on my submissions depended upon whether there was a second contract in play or not.
Well,
but I was asked to explain the status of.
Yeah, no. Well, fine. But my lady very said it was all her fault. Well, I mean, she was saying it because you were referring to it.
Yes, I'm sorry.
I think it's
No, I'm not complaining.
okay. Well, at the moment, speaking for myself, but I suspect from my lord and my lady, or say if not, I think it's a bit of a side issue about the amended claim. But while I just from my notes, I've been thinking of it as IIR, but is that meant to be a Roman? Is it 2R with the Roman letters, or is it IIR? Doesn't.
I've always referred to them as 2R.
Okay,
like
well that's
2R.
probably what it is. I just misread it.
And this isn't my first case, which is involved.
Okay, thank you. No problem.
Um,
Right, now, where next?
The underlying claim, summarised in paragraph 6 of the skeleton argument, subject to the exchanges we've just had regarding the second, the first in time type 2R contract. But the claim complains about the award of either one or two valuable contracts for face masks. The contract in the original claim form, at subparagraph 8 on page 6 of the skeleton, is worth over 100, or was worth over 100 million pounds. And that contract, and we say the type 2R contract as well, appears to have been awarded following personal intervention by a senior Downing Street official and by the Home Secretary, who, from the correspondence which we have received and have put before the court, had a personal connection and relationship with at least one of Mr. Shergill and Mr. Jassal, who were working for the interested party to seek to obtain contracts within government.
Well, we've seen all the details summarised in paragraph 6. We don't need to go over it in great detail, do we?
No.
Or in any detail.
No, my Lord, but the court does need to understand that the allegations made in the claim are serious allegations. This, my client would say, is not how £100 million contracts should be awarded. And the way in which that is formulated, and I accept it's in the summary, in the statement of facts and grounds as amended, is at page 225 of the supplementary bundle, and there are claims set out on 225 from paragraph 37 onwards, a common law claim, both as regards apparent bias and taking into account irrelevant considerations. That's paragraph 37. And then paragraph 38, a claim based on the Public Contracts Regulations 2015. And the point in relation to that is both the personal connection and personal intervention point, and also that prior to the award of the £102 million contract, there were a number of different suppliers who were offering the same masks to the government, and there is a complaint of breach of equal treatment in paragraph 38. Which arises out of how and why the interested party was chosen for the contract, despite offering masks at a higher price than others.
All you're ultimately seeking are declarations that decisions to award were unlawful.
Yes, declaration.
What does that then entail?
So a significant point about both contracts, but certainly the FFP3 contract, which we're focusing on, is that, I'll show you the document in a moment, that it was due to be performed, and we understand was fully performed, between July and November of 2020. So the contract is over. It's been performed. We've only ever sought a declaration as to the legality of the entering into of the contract, and we've never sought to disturb, and it would have been too late to disturb any of the implementation of the contract.
So this is not a classic procurement challenge, no, which is where disappointed supplier B complains of the award of the contract to successful supplier A, and by definition has to do so very quickly, because otherwise the contract will go ahead.
Yes.
Yeah, well,
it's not a classic in that sense, but also in the sense that it's a third-party NGO, which is the claimant, but it's also not typical in that a procurement claim will either be generally to stop the award of the contract and rerun the tender process, or to claim damages for what was lost if the contract has gone ahead. And we're not seeking to do either of those things, but simply seeking a declaration.
So what's the point of it?
Well, the point is for the court to identify and acknowledge unlawful conduct by the government in the award of a very valuable contract.
But normally the purpose of determining that something's unlawful is so that then has consequences. A mere declaration that something was unlawful with no consequences seems to be academic. That's the classic definition of academic, isn't it?
Well, in my submission, not. And this is an argument which Mr. West and I have had in other cases concerning the award of contracts for PPE, where Mr. Justice O'Farrell has rejected the argument that it was academic simply because the contract had previously been performed and only declarations were sought.
But forgive me, in public law cases, aren't we all the time saying, well, that relief is sought, but it's now academic because the person has now gone back to whatever country they were, or because the government has remade the decision, so whether or not the original decision was unlawful or not is now academic? I mean, isn't that what academic means? Well, it no longer has any consequences.
Well, that in my submission is not what it means in this context, and it would be far from academic, and we say would be important for the court to acknowledge the unlawful conduct which has occurred, and the court very often makes declarations to do just that. There are,
your best case of an award of a declaration where all it could ever do was mark serious unlawfulness by the government?
I'm sorry, what is it?
Can you just give us an example of such a case? A case like this, where it's all, in a sense, water under the bridge, but you're saying it's important that the court identify and acknowledge, as your phrase, unlawfulness on the part of the government.
Well, this is a...
If this is ground you've been over before in front of Mr. Justice O'Farrell, you must have the cases at your fingertips. I mean, was the Pierre Dam a case of that kind? I can't remember. But, and that was controversial on other grounds, but was it said to be academic?
No, I don't.
Because it was still ongoing, because the money was still to be spent.
But look, there's there's a difference between a case which is academic because the government has changed course or the individual has achieved what they were seeking by other means. For example, the Salem case, the classic authority on academic claims. But this is a case where the government has not acknowledged illegality, where the claimant has not.
I'm sorry, Mr. Copeland, that wasn't my question. My question was, you say this is. You said earlier this is quite a common type of case. I just wanted an example because and I thought there probably are several, but I don't know what they are. Or is this actually quite new ground?
Well, Lord, in terms of judicial review of procurements, it is relatively new ground. There was a case which came before the Court of Appeal and my lady quite recently, where Mrs. Justice O'Farrell granted a declaration as to the unlawful award of a contract. Now, she was held to have been wrong to do so on substantive grounds, but in the course of that, so it's the public first case which you have in the final tab of the authorities. In the course of that, she rejected the defendant's argument that the claim was academic in its entirety.
Yes.
Well, because the contract.
We can look at that if necessary. Sorry, I've rather taken over my Lord's line of question. He may want to ask me about it, but I was just picking up on the answer is there is no obvious authority which says, no obvious appellate authority which says this kind of challenge isn't academic.
Well, Lord, I'm not giving you
None
one
that you can think of
right now, but
okay.
I'll,
No, but,
Mr.
okay, that's all I want to know. But my Lord may want to resume what he was asking, or he may have heard sufficient at this stage.
Well, I mean, obviously, this isn't obviously the primary area that we're concerned with here. But just so I understand, for example, the claims concerning apparent bias, and it says that the contract was vitiated, but that's not right, is it? Apparent bias might make the contract voidable, but it wouldn't make it void, would it?
Well, I think we would say as a matter of public law, if the decision to award the contract was tainted by apparent bias or by some other.
But you said this is a claim as a matter of common law.
I understood you to mean common law. It said ordinary public law unlawfulness rather than by reference to the 2015 PCR regs.
Yes. So yes, we would say, and again, the first instance authority in public first is just an example. If a decision to award a contract is tainted by actual bias or apparent bias, then a declaration as to its illegality should follow. But we're not and have never sought to undermine the contract, to strike down the contract.
Well, as you say, that certainly would be academic because it's been performed.
Yes.
You're not a party to it anyway. So.
Yes.
Yeah, you're challenging the decision to award the contract.
Yes.
That's an ordinary public law claim. Yeah. Yes.
So then so it's public law, common law grounds, and then public contract regulations on page 227. Now, if the factual allegations made in the case are well founded, if they are, we say that would be a matter of significant public interest, and we say that there would be very real prospects of success on the pleaded grounds. Now, you don't have
So we can't possibly take a view on that. I mean, I'm just looking at the letter of response. Amongst other things, it said that time expired on the 19th of April 2021. Your date of knowledge arose. So, I mean, I understand for present purposes that's not a point that arises, but that is factual context, as I understand it, and that's a point that's being maintained.
Yes, and it's a bad point. But yes, sorry, I was going on to say that you don't have a defence, and of course I'm not asking you to accept that the claim does have merit.
So that's said to be unarguable by the respondent.
said to be, and if it is, then it won't get permission. But insofar as the substance of the claim is relevant, and I say it's relevant to the public interest in the proceedings, to any prejudice suffered by the defendant, I am inviting the court to proceed on the assumption that the claim either is well-founded or that it may be well-founded.
Right, so you want us to proceed on the basis it's arguable, do you?
Well, at least arguable, yes.
Well, yeah, that's really all you can do, isn't it? We can't possibly, in
No.
these proceedings, effectively preempt the decision of the judge at an eventual hearing.
No, of course.
We should proceed on the basis that, at most, and Mr. West may say we shouldn't do even that, but we should proceed on the basis at most that it's arguable. That's fine.
But the analogy is with a strikeout application, where the court assumes that the claim is well founded, or that the facts alleged
Well, that's a different point.
will be provable. But more, I'd say I'm not asking you to accept that the claim is well.
Sorry, that's just wrong. Forgive me for interrupting. But you assume the facts to be true for the purpose of a strikeout, based on it's unarguable, even taking the facts as they stand. That isn't applicable here at all. I think going back to my Lord's point, you submit, and it's not been positively argued for the purpose of this application to the contrary, that it's an arguable claim.
Yeah. You are entitled to say we should proceed on the basis that it's arguable, and if, in the event it proves to be right, it would be I forget what exact phrase you've used, serious and significant matter, or
A matter of significant public interest.
matter of significant public interest.
Yes.
Okay. Right, well, that's already all we need to know about this side, isn't it?
Yes. So, part 2, the chronology of events. Supplementary bundle, please, page 3. You have the contract award notice which gave rise to the claim. And the publication date, you'll see on page 3, is 29th of March 2021. Going over the page at the bottom, you see it's a contract for FFP3 respirators.
Do we need any more than that this was?
And page 7, my lord, sorry, I'll skip to page 7 if I may. The date of conclusion of the contract is the 7th of July 2020. Now, the defendant had an obligation under the regulations, and I put regulation 50 on your desk so you can see that, to publish a contract award notice within 30 days of the award of the contract. So in early August last year, early August 2020. In the event, it's not published until March of the following year, and I don't complain about that, but it does put the question of urgency and time sensitivity of the steps in the proceedings in some perspective.
So it says submit for publication. There's nothing in that. Is that right? Regulation 50. It's automatically published.
Yes, it gets sent to the contracts finder database. It used to be the official journal. So substantial delay in publication. My clients become aware of the contract through the contract award notice, and they then come up against a short time limit, and that time limit is in CPR 54.5. And can I ask you to turn that up, please?
Yes, rather unhelpfully, the rules aren't in the authorities bundle. Perhaps you were trying to save paper, though there's not much evidence of that. But on the basis that we'd have the white book in court, but actually it's quite useful to have the real thing. So have not the real thing, so we can write on it. Anyway, don't worry, I've got that off my chest. Yeah,
54.5, page 2011.
Yeah.
And the first point is the standard time limit for judicial review is in subparagraph 1 is the promptly and in any event not later than 3 months. The claim form must be filed within that time, and in contrast to the position with an ordinary civil claim, a judicial review is commenced by filing the claim form. That's what stops time running.
Hang on, is that right?
I'll show you in due course 7.2,
Yes.
which says that a claim is started when the claim form is issued.
Yes.
But here, what you need to do to start a claim is to file it with the.
Well, I'm not sure that's
with
right
the
at all. It says it must be filed. That's not the same as saying it's issued. That's not equating filing with issue. There undoubtedly is an obligation to file promptly, but that doesn't say. Well, you say it's outside 7.2.
Yes, it's what starts, and it may be a hangover from the tradition of judicial review as an application.
Mm-hmm.
But what starts the process and starts the claim is the filing of the claim form, and one sees in subparagraph 3 perhaps a hint of that. This rule does not apply when any other enactment specifies a shorter time limit for making the claim.
Well, we're in this. I always have to restrain myself when talking about the drafting of the civil procedure rules, but one of the many respects in which they're inadequate is we're in this ludicrous position with Rule 7, whereby the claim is started by issue, but time runs from when it was filed. And because of a practice, in the ordinary common law cases, because of a practice direction that says that, or practice note or something. Have I not got that right? So for limitation purposes, in a non-judicial review case, although the claim is only started when it's issued, which may be some days later from when it's filed, time runs from when it's filed. Or rather, no. I don't mean time runs when it's filed, I mean you satisfy your limitation by getting it in for filing.
Yes, for a claim that's covered by the Limitation Act.
Yes.
There is a special provision that for limitation purposes, it's when the claim is received in the office. And then there's the electronic working system, which is
Anyway, that's all by the by. But you were it's background, or it spins off your point that in this case the claim is started by filing, not by issuing. Well,
yes.
Does that matter anyway?
Maybe only slightly, but it does matter to the judge's findings on ground 1,
yes,
which I appreciate.
That's why. So 7.2 is now irrelevant because the judge obviously dealt with 7.2. You say apart from 3.10, the 3.10 issue that doesn't engage here.
You've dropped ground 1, haven't you?
Yes, absolutely.
Yeah, so,
but it may matter slightly to other aspects of my submissions.
Well, all right.
But
I think let's get on with the points that really matter.
So, subparagraph 6 then, where the application for judicial review relates to a decision governed by the Public Contracts Regulations, the claim form must be filed within the time which an economic operator would have been required by Reg 92.2 to start any proceedings. And that is in the authorities bundle at tab 3.
We need to go to it? Just tell us
no, 30 days from date of actual or constructive knowledge.
And it's common ground that despite the point that we made, we noted when looking at the statement of facts and grounds, that this is a decision governed by the regs within the meaning of 54.5A1.
Yes, and we have a complaint under the regulations, as you saw, for breach of equal treatment. So at least the regulations claim is governed by the 30 days. It may be open to argument whether the common law claim is as well, but at least the regulations claim. The claimant's solicitors acted promptly following the 29th of March contract award notice, and at page 122 of the supplementary bundle, you see a pre-action letter of the 8th of April, which sought a response within 7 days. I'll take this relatively quickly. At 132, Mr. Olson of the Treasury Solicitor replies saying, we won't be answering for 14 days. And also in the second paragraph of his letter asking for future correspondence to be copied to him and two colleagues who were included in the email attaching the letter on 132. The pre-action response is on 138. And it's paragraph 4, gives the instructions for electronic service. Proceedings may be served by email to new proceedings, and we request that any new legal proceedings served via that email address are also copied to the individuals included in the email attaching.
I think the way I put it to you earlier is therefore correct, isn't it?
So we are requested, if we're serving by email, to serve at new proceedings and to copy to 3 other individuals.
Yes.
At 144, the claimant replies the following day, saying that in light of the 30-day time limit, they're likely to have to file a protective claim at the bottom of the page, and inviting the defendant to agree a stay of proceedings to allow the parties to correspond further. And on 147, 146, the letter begins, the defendant agrees a stay at 147, but for a longer period, a stay pending the determination of other claims in relation to purchase of PPE. That's the third paragraph on 147. Those claims there mentioned were decided by Mrs. Justice O'Farrell last month, and they may or may not go on appeal.
Sorry, they may?
They may or may not go on appeal. That remains to be. So Mrs. Justice O'Farrell decided that what was known as the VIP lane, whereby suppliers who were known to government ministers and senior officials got an advantage in the procurement process, that was unlawful, but she refused to grant relief in relation to that because she said that the contracts in question would have been awarded.
But again, my fault, just in a nutshell, did they succeed or fail?
Well, they succeeded in that respect and they failed in other respects. No relief was granted.
On any of these claims?
On any of those claims.
So all 4 have been dismissed?
They've been dismissed.
So she didn't grant a declaration?
She didn't grant a declaration because she decided, and if the cases do go on appeal, it'll be in relation to this, because she decided that that the same contracts would have been awarded to the same suppliers in any event, even without the unlawful VIP loan.
Who got their costs?
And the defendants got costs. So the defendants were successful, save for the finding in relation to the unlawful VIP loan.
But certainly the judge's view was that that did not represent substantive success.
Yes.
Because the defendants got their costs.
Well, I'm sorry. The judge hasn't made an order for costs.
Oh.
My client won't be disputing that
Yes,
they're liable for costs. The consequentials haven't been dealt with yet.
Yes, I see.
But the point I'm making here is that the defendant was keen for a longer stay, and in terms of urgency, again, that puts the matter in some perspective. 148 is Bindman's, the claimant solicitors, serving the unsealed claim form to new proceedings and the three individuals from GLD. That's Mr. Olson, Ms. Donnan and Ms. Smith in the CC line. And GLD is informed in the body of the email that the claim form and bundle of documents have been lodged at the court today. And we say that that GLD is thereby informed that the claim has been started, because that is the step that needs to be taken to start the claim. Mr. Olson confirms receipt of the unsealed claim form on 162. And at 164, you have the email from Bindman's, which attaches the sealed claim form on the 28th of April, which is not copied to new proceedings. Someone can see how this happened. The email below on 164 is Mr. Olson's acknowledging receipt of the unsealed claim form, and Mr. Olson has taken new proceedings off the circulation list. He's replied to Bindman's, but he's removed new proceedings from the list of recipients, and then a reply is made to that email, and it doesn't then contain the new proceedings address.
So I don't see the new proceedings that was taken off. Page 16.
So the first email is 148.
Yes.
Which is sent to
Yes.
primary address new proceedings. Mr. Olson acknowledges receipt on 162.
Yes, I see.
He perfectly properly
Yeah.
takes new proceedings off, because new
Yes.
proceedings is not meant to be
Yes.
cluttered with
Yes.
post-service correspondence.
Yes.
But Ms. sorry, I've forgotten her name. Ms. Gallivan
Yes.
doesn't pick up that that has happened. One can quite understand why one wouldn't, but she didn't.
Yes. So I'm just trying to.
Yeah, it's helpful to see how it happened.
Now, the next event is on the 6th of May, when Mr. Olson informs the claimant solicitors that there has been ineffective service, 175.
But you might have wanted to refer to 172.
Yes, I'm sorry. I was going to come back to that. On 172, Mr. Olson sends a letter to the claimant's solicitors regarding disclosure in the claim. Now, it seems, it's not entirely clear, but it seems from Mr. Olson's witness statement that the failure to serve new proceedings with the seal claim form was picked up when it happened. And nothing was said about it. He corresponds with the claimant about the claim, and then waits until the time limit has expired on the 6th of May to inform the claimant that there's been ineffective service.
But to be fair, he's not replying here to anything that happened on the 28th of April. He's referring to the letter of the 27th.
Yes.
But I thought, I think it's interesting for your purposes here, is it looks as though he's suggesting that the defendant already has a counsel team in place in relation to this matter.
Yes. Yes, he is. Yes.
Is that right? It's in the DPE claims. I think isn't that in relation to the other claims?
Well,
Well, he's talking about the other claims, but it's the same. He's saying we're two.
Of course, we've got a council team, but my lord was.
Well, he's suggesting that it's. He's suggesting, isn't he, that I mean, the way it's framed is obviously he's suggesting that the client and counsel team haven't been able to deal with this matter because they've been dealing with that matter.
Exactly. So it's the same counsel.
The reality, presumably, is that they have a counsel team, as you would expect, for PPE claims, which are largely, perhaps only, I don't know, claims brought by your clients, but we know there's more than one.
Yes.
And the assumption, perfectly sensible working assumption, is the same team will be used on this one. But he said we haven't had a chance, but they haven't actually worked. They haven't been assembled for this one. They're the pre-existing team, and they haven't had a chance to look at this claim yet. That's really what is being said, isn't it?
Well, I don't know for sure when the council team was assembled, but there was a pre-action response on the 22nd. One would assume that the council were involved in that.
Well, no, sorry. Well, all right, but maybe not. But I mean, that's not really not the point. The point is that a team has not been assembled. You can't take the point that a team has been assembled to deal with this specific claim. It is clear that the team who it is expected will deal with this specific claim are the team who are already instructed in relation to the PPE claims. That's both common sense and what appears to be being said.
And they're busy on something that's
Yeah.
on
Okay.
those claims. But it's a letter engaging with the claim, or at least saying we'll be engaging with it shortly, which doesn't refer to the error which Mr. Olson appears to have noticed when it happened.
I dare say you're right, but since it is to a point to which you attach some importance, can we just see, or are you going to take us to it later, what Mr. Olson said?
Yes, so it
makes that clear.
I'd say it's not entirely clear. 117 of the supplementary bundle, paragraph 19.
Well, it's completely silent on whether he understood it at the time, isn't he?
Well, my lord, he describes what he perceived on the 28th. What he perceived from the email that was sent on the 28th. I agree, it's not entirely clear whether he's saying that based on his initial look at it, or based on a subsequent.
Not entirely clear. He's completely silent on the question. Am I missing something?
Well, what I say he is describing the email that he received at 13:44 on the 28th of April. He doesn't say, and I noticed at a later stage.
But nor does he say, I noticed at that stage. He just recites the fact that new proceedings was not an addressee. Oh, there we are.
Well, that's what he says. If that's read as not saying one thing or the other, well, fine, that's what he says. In any event, by the 6th of May, he has noticed.
Yes.
The day after 7 days expired, and he informs the claimant on 175, and at 177, within an hour of being informed of the problem, Bindmans have sent the sealed claim form to all the appropriate addresses. I say within an hour, it's an email timed at 17:28. Mr. Olson's is 16:37. Before I make some brief submissions about the chronology, I've been referring to the period, the 7-day period. It's 54.7 on page 2015 of the White Book, and that's again a contrast with the normal position for a civil claim. And another point of contrast, which you don't need to turn up, is that under the practice direction for Part 54, paragraph 6.1, it says that the administrative court will not serve proceedings. So the parties must, in all cases, serve judicial review proceedings, whereas the normal position for a civil claim is that the court serves, save where it's asked not to. So the claimant in a JR has 7 days from issue, and they have to serve the claim themselves.
And that does what? What's the rationale, do you think, for that distinction? Well, it may be purely administrative, I suppose.
I don't.
But it could be said, could it not, to underscore the importance of Timia's service? Puts it in the control of the parties, the obligation on the parties.
Well, it may be that the court doesn't want to be burdened with having to act so quickly. I don't know, but that's a contrast with the normal civil claim.
Not clear to me that client solicitors have anywhere given an explanation of why they didn't add the new proceedings address on to their email.
Well, Lord, you have the statement of Mr. Potter, which describes what.
That's what I'm looking at. I can't actually see any explanation in there as to why. Was it a mistake? Was it a deliberate decision? I mean, from later in the statement, it looks as if it may have been just thought that it was good enough to send it to the other addresses, but it's not clear.
Well, the way that I've always put the claimant's position and what the judge decided was that it was a mistake.
A careless mistake.
Yes, I think I agree. Perhaps it would have been better if it had been explicitly spelt out. But what you told us as we were going through the document seemed to me to be the obvious common sense. He does say at the end of para 13, page 46, by way of this email, it was understood we'd notified the new proceedings email's address. So it does look as though we thought wrongly we'd done it. So I think that rules out anything deliberate. As you say, that's never how it's been suggested. But he doesn't really explain how it came about. But you suggest that the obvious and plausible explanation is that they were simply following the email chain, which had started with an email to new proceedings. He didn't notice that they'd come out of the chain in the intervening exchanges.
It's difficult to, I mean, one can imagine what goes on behind the scenes here, but the obvious point to make is that Miss Varley was replaced by a trainee solicitor. That's if you follow it through, and it's not for us to speculate. As my lord say, we've got what we've got, but there is no explicit explanation as to what happened or why.
Well, frankly, I'm not saying this is expressing any view about the merits of the appeal, but as realistically, it is a mistake which anyone not being very careful could imagine themselves making, whether a trainee solicitor or someone more senior.
Yes. Yes.
But it's still a mistake.
It's still a mistake.
Careless.
Yes.
Yeah.
Absolutely. And we never sought to shirk from that.
No.
And normally, though, when you're asking the court to act on the basis that a mistake has been made, you normally have to say you made a mistake and explain it, or at least. So I can't actually see anywhere an explanation as to what happened, or indeed an assertion that it was a mistake.
Well, that was the explanation which we gave to the judge and which she accepted. I take Law's point about the way the statement is phrased, but there's never been any doubt cast on that explanation. So the points that I would make from the chronology briefly are, first of all, the defendant has never suggested that any prejudice whatsoever was caused as a result of the omission to send the sealed claim form to new proceedings on the 28th of April. And that's easy to understand because, of course, all that happens with proceedings which are sent to new proceedings is that they are picked up and distributed to the relevant GLD case holders, who, of course, were recipients of the 28th of April email. And Mr. Olson asking for new claims or for any new claim to be sent directly to the case holders is precisely so as to avoid any delay that might happen between the claim being received at new proceedings and being sent to the people who are dealing with it. So this is an entirely technical point. Maybe it may be a significant point, but it's an entirely technical point in terms of prejudice to the defendant. The second point is that the claimant solicitors acted promptly at all times. They complied with a very challenging 30-day time limit. Pre-action letter issued within 8 working days of the contract award notice. Proceedings issued within 3 working days of the defendant's pre-action response. They sought to serve the sealed claim form immediately that it was issued. And you will have seen lots of the ordinary civil cases where the courts are very critical of claimants who court disaster by waiting until the very last moment of a period limitation or a period for service before seeking to serve. We sought to serve at the first moment in the period, but because we weren't told of the mistake until the day after the period had expired, there was no opportunity to correct it. And I'll come back to the significance of the difference between the ordinary civil period for service and the judicial review period in due course. Thirdly, the defendant makes a number of submissions, and we saw the judge accepting one of those submissions in paragraph 71 on the Denton test. A number of submissions regarding the importance of procurement claims being pursued without delay. And that is correct. As a general proposition, there are tight time limits because, as my lord pointed out to me, there is usually some urgency. Either the defendant authority is in mid-tender process, or it has awarded a contract and it wants to get on with signing it and implementing it. But this case is very far away from that paradigm situation. Contract not publicised until almost 9 months after it was signed, 4 months after it was fully performed. And then we have the application for the stay, or the agreement by the defendant, and application for a stay pending the other PPE cases. And to complete the pictures, just so the court isn't in any doubt, after Mrs. Justice O'Farrell's order in this case, the claimant issued...
So you're not taking a point in that connection with the point I made to you about another reason why there isn't any urgency, which is that it's not an attempt to stop to invalidate a contract that's already been awarded.
Yes, some Lord, I do take that point. I just didn't say it again as I.
No,
but yes, I
just wanted to be clear.
I'm sorry. I do say that's that goes to urgency. Yeah. Yes, just to complete the picture, the claimant issued a fresh claim after the order of Mr. Justice O'Farrell with an application for an extension of time. So it was a claim that was out of time, or certainly out of time in relation to the regulations challenge, with an application to extend time, and that has been stayed.
Yes. Yes, you didn't mention that's part of the chronology. What was the date of that?
I'm sorry, give me one moment. I believe it was in.
I saw it referred to, but I didn't pin down where.
Yes, sorry, I should have that at my fingertips, but I'll get it.
Sorry, I don't understand that. So you've issued a fresh claim form after the decision here. Same claim.
Yes. Well, same as in reflecting the amended, the proposed amended.
Right.
What was the date of that? Oh, sorry, that's what you
of the second claim. I'm being told shortly after.
How does that work? I'm just thinking out loud. If you succeed here, you don't need it. If you don't succeed, then you're going to make another 312A application or another.
Yes. But it's an application to extend time for bringing the claim, not an application to extend time for service of a claim brought in time, which is this case.
It's hard to see how you could be in a better position on that application than on this one. And if you were, something had gone very wrong with the system.
Well, my lord, we at that stage didn't want to leave any stones unturned.
Because on this claim, as you put it, it's a mere technicality as to where as the address you used on the email. There, you are genuinely out of time.
Yes, although we're out of time because of
the mere technicality.
Yeah, but that doesn't do you well. You have the point.
My lord, you
have the point. We
yes,
won't beat you to your knees about it.
Quite good to have the date.
But it's surprising that the one behind you can tell you the date.
Yeah, I'll tell you this. Well, given the time and that I've gone to some provisions of the CPR already, I'm not going to go to the other relevant CPR provisions now, but I will come back to them when looking at grounds 2 and 3.
Can I ask you one thing? Just see whether I've understood this correctly. In 54.5, when it is talking about filing a claim form, It must there be referring to an unsealed claim form.
Yes.
So why does a reference to claim form in 54.6, sorry, 54.7, be a reference to a sealed claim form?
We have taken the view that because of the general rule that claim form means sealed
Which is 2.9.
claim form and reinforced by Ideal, and the final words of 54.7 within 7 days after the date of issue, that's at least a strong pointer that it should be a sealed claim form. But the point does arise for potential argument because of the contrast between JR and civil proceedings, where the claim form will always be sealed once proceedings are started. But we don't take that point.
No, wrong false one. Come back to it.
Well, the 30th of June was the date of the second claim.
Thank you.
Ground 2, then, if I may, and perhaps we can look at 6.15 in the White Book at page 331. And the issue for the court, as you know, is whether it appears to the court, subparagraph 1, that there is a good reason, or good reason, as the authorities say, to authorise service by a method or at a place not otherwise permitted by this part. Now, we accept that we sought to serve the sealed claim form by a method which was not permitted by this part. The reason for that is 6.3, as the judge set out in her judgment. CPR 6.31D, a claim form may be served, this is 307, a claim form may be served by any of the following methods, other means of electronic communication in accordance with Practice Direction 6A, and Practice Direction 6A on page 400, paragraph 4.1, where a document is to be served by other electronic means, the party who is to be served, or the solicitor acting for that party, must previously have indicated in writing that they're willing to accept service by other electronic means and the email address to which it must be sent. Interestingly, it doesn't say in terms that you must then send it to that email address.
I think you're wise not to make a point on that.
But that's implicit. So we served by an alternative method, not permitted, and that's 6.151. Before I take you to the leading case, which is Barton, I have to show that the judge erred in principle or reached a conclusion which was wrong.
The test set out in Barton itself, isn't it?
Well, interestingly, my lady, the assumption in paragraph 15 says plainly wrong, which is a gloss on Abella, paragraph 23, which he was.
But this has been a long,
wrong.
wrong, plainly wrong. They all mean the same thing. but I agree the orthodoxy has tended to be to say it plainly doesn't add anything. We need to spend time on that. Need we?
The context for Barton is that it was concerned, like all the cases in the bundle, with ordinary civil proceedings. You have a 3-year or a 6-year limitation period. You have 4 or 6 months to serve the claim for. Under 7.5. That is described in one of the authorities in the bundle as a generous period. That's the Tiger Falkirk case, tab 36, paragraph 67. The claim form is usually served by the court, so the cases are universally concerned, almost universally concerned, with the exceptional situation where the claimant has opted to serve himself or itself, and that's usually for tactical reasons. It doesn't want the claim form served immediately. Now, if a claimant acts in good time within the 4-month period, any misservice can be corrected before the end of the period, as the defendant will have to acknowledge service and will have to say at that point whether it accepts that service has been validly made. So if you act in good time within the 4 months, you will be told if you have used the wrong email address or done something else, and you will have time to correct it. And again, almost universally, the cases are, like Barton, concerned with claimants who, as Assumption puts it, court disaster by issuing at or near the end of the limitation period and then attempting to serve at or near the end of the time limit for service. And as in Barton, claimants who do that generally get short shrift. Now, there are a number of differences between that archetypal civil situation and judicial review. In judicial review, you have the tight time limit for issuing, 3 months, or in our case, in fact, 30 days. The burden is on the claimant to serve, and the claimant only has 7 days, not 4 months, in which to do it. The defendant then has 21 days after service in which to acknowledge service. So the defendant will not have to say within the period available for service whether it accepts that service has been validly made. It can wait until the end of the period, as happened here, and then make its objection.
Why is that different in a civil case? The defendant in a civil case doesn't have to acknowledge service.
Well, it doesn't have to. I mean, it's
Well, the defendant can do nothing, and then when you apply for default judgment, then he comes along and says, "But you can serve."
He can do nothing. That is true, but there is a mechanism in the rules for objections to service to be taken, and if you've acted in good time, that will.
Well, that didn't happen in Barton, did it?
Well, he served on the day before the period for service expired.
Yeah, but the solicitor said nothing.
They said nothing on that day, and Lord Sumption says that was to be expected. But if Mr. Barton had served on day 1 of the 4-month period, as we served on day 1 of our period, and the solicitors on whom he sought to serve had said nothing, the answer may be different.
Well, it might have been.
There's no question in a judicial review, as there is in a normal civil claim, very often, of a claimant having an alternative recourse against his solicitors. So very often what one sees in the cases is a solicitor error, and one of the factors is well, if the claim can't proceed, the claimant has an alternative, not as good, but an alternative form of recourse against his solicitor in respect of the error. That generally, almost universally, will not apply in judicial review.
Why?
Because it's not that kind of, because they aren't money claims. The claimant will usually not have lost financially as a result of the
Costs.
claim not being.
Costs. And I mean, I can see all sorts of remedies in a solicitor's negligence claim for an error in judicial review claims, presuming there's a genuine interest in the outcome, not necessarily pecuniary. Anyway.
But you wouldn't get, your point is you wouldn't get the thing which you were bringing the case for, namely a declaration that the public authority has acted unlawfully, whereas or quashing of an order or something, because you can't get that in the solicitor's negligence case.
Yes.
But if you're in a procurement context trying to interfere with the tender process, and you lost the opportunity of challenging the tender process and thereby securing a retender and the award of the contract,
Yes.
there will be every means
Well, you wouldn't
securing a remedy.
You wouldn't be bringing your claim by judicial review if you were interested in the tender process. You'd be going on to the regulations in the TCC.
Right. So you'd have no common law claim for apparent bias by way of judicial review.
Well, you may be pursuing that claim in the TCC, but an economic operator who's competing in a tender process can't bring their claim by judicial review. They bring it in the TCC as a Part 7 claim under the regulations.
Yeah.
I hadn't really thought that through. It's not my field. So 54.6 is rather odd. It's referring to a kind of case referring to or relying on a breach of the PCR 2015, which will be an untypical type of case.
Yes.
But as this case shows, it can happen.
Yes, and what it's doing is saying, well, even if you're not an economic operator, you ought
No, I've got it. I'm sorry.
to proceed as quickly as an economic operator would have to proceed. I mean, just take this claim. There's this type of claim. There's no question of recourse against a solicitor.
Anyway, this is not your biggest point, is it?
No, it's not.
It has very different weight even in ordinary time cases. Some courts say it's there, and other courts say it's not much use really. So I think we should focus on the points that are central.
Absolutely, more. And so the next point of contrast we say is that there is in judicial review a different relationship between the parties and between the parties and the court in a judicial review than in a civil claim, and that is in particular because of the defendant's duty of candour and cooperation. I put the Poirot.
Is this another central? I don't remember this being in your skeleton argument, and I can't see what it's got to do with it really.
Well, so what it goes ultimately to prejudice, and the
How?
well, because a defendant who is not having to face an arguable judicial review claim, as we're assuming that this one is not prejudiced. I'm sorry. A defendant who is facing an arguable judicial review claim, or who has to face it because of an order under 6.15, is not prejudiced in the way that a claimant in an ordinary civil claim would be prejudiced, and that is because judicial review is not to be viewed as simply a relationship between the parties, but the defendant is engaged in a common enterprise with the court to get to the bottom of judicial review claims in the public interest. That's the duty of candour and cooperation, which is set out in is explained in the Poirot case. So when it comes
What
to
case?
Poirot, which is
Oh, the Chagos
this is the Chagos, and
Is that why you've handed up this?
that's why I handed it up, and it's.
It's a rather bleak way of simply making the point that a public authority is in a different position from a private defendant, because it's to some extent, if it's a public authority, ought to be neutral about the public interest. Well, I'm sorry, I put that badly, but it's the point you made last when we pressed you. It ought to be concerned about acting lawfully, effectively.
Yes.
Yeah. Okay.
Well,
What's the passage you're referring to in the Chagos case?
So, paragraph 16, the citation from Huddleston, where judicial review is described as creating a new relationship between the courts and those who derive their authority from the public law, one of partnership based on a common aim, namely the maintenance of the highest standards of public administration.
Yeah, well, now I understand how it fits in. That's fine. I see the point.
There's further reference to the duty of candour and cooperation in 19 and 20.
Okay. Yes. As Bailey says, this is in the context of disclosure, but you say disclosure is simply an illustration of the wider principle.
Yes.
Yeah. Okay. Well, I have the point.
The Barton case, then, that is in the authorities bundle at tab 25, page 484. And I know you'll have seen cited both in Mr. Justice O'Farrell's judgment and in a number of the other cases. The key.
Well, speaking for myself, I'm pretty sure, for my lord and my lady, we have read it quite carefully. So I don't think you need to take us through it laboriously, but obviously there are passages you will want to refer us to.
So paragraph 4, letter E, is the basic fact.
Well, this is just something you needn't do because we read it carefully. Don't you want? And this is a particular point you want to draw out of it.
Yes, I'm sorry, I should leave that. So paragraphs 8 to 10 are the principles. And paragraph 8, there's just one point I wanted to make from that, because my learned friend relies on it. Between letter E and F, the main difference the law assumption identifies between 6.15 and relief from sanctions cases is he says the disciplinary factor is less important. And the only point I make about that is he is not saying that the disciplinary factor is unimportant or irrelevant. It is simply less important than in the sanctions cases.
Can we just pick up, though, one thing from para 7? There was originally an application for an extension of time under 7.6, but that was refused by the district judge, and that decision was not permitted to be appealed. So, in fact, originally at the district judge stage, they were firing with 2 barrels, just as you are here, but 1 barrel wasn't allowed to go any further. Missing my metaphor. Yeah.
Yes. And we'll see that Lord Sumption thought that was of at least some significance to the analysis. Paragraph 9 is then the summary of the principles in Abella. And subparagraph 2 at the top of the page, the critical factor being that the contents of the claim form are brought to the attention of the person to be served. I need to come back to that. Subparagraph 4, letter C, the object of the new 6.15 was to open up the possibility that in appropriate cases a claimant may be enabled to escape the consequences for limitation when a claim form expires without having been validly served. So as I'll submit it, it can't be the case that depriving the defendant of a limitation defence is conclusive. That was one of the points of the power being inserted in the first place.
The situations where there's no limitation issue, one really doesn't end up arguing about it in the Court of Appeal.
Yes. And paragraph 10, one sees law assumption is not purporting to give a complete statement of the principles, but only see between letter D and E the main relevant factors, and then sets out the three factors that I'll come back to when I look at the judge's judgment.
Could I just ask you about the phrase in relation to 3, as part of 3, bearing in mind what he knew about its contents? Does that mean, broadly speaking, that there's not likely to be much prejudice if the defendant knew from the in deciding whether there's prejudice, you must take into account what they already knew, because although it may have been misserved, they'd actually seen it.
Yes. Yes, and we submitted to the judge that's the primary question, at least when you're looking at prejudice, is what is the prejudice caused by the error, caused by the misservice? Did it make any difference to the defendant's knowledge of?
Yes, I mean, I see that, and that's, in a way, it's obvious. The only reason I was spelling it out was I wasn't quite sure how it then fits in with what Lord Sumption later says about limitation.
Yes, so he then looks at it, what we say is a different aspect of limitation, and him and Lord Briggs disagree on that point, which I'll come to that in a moment. But it is at least highly relevant whether the defendant has suffered prejudice as a result of the misservice.
Yeah, anyway, none can be correct. It's decisive, weight, vary all the circumstances. So, right, where are we going now?
And then we are going to paragraph 16. And on the first of the factors, the defendant's knowledge, Lord Sumption explains it can't be enough that the claim form was brought to the attention of the solicitors, and see between letter E and F. It's the manner in which this is done is also important, and the reasoning at the bottom of the paragraph. Otherwise, any unauthorised mode of service would be acceptable, notwithstanding that it fulfilled none of the other purposes of serving originating process.
Well, you've left out, surely, an important passage just by F. This is because a bright line is necessary in order to determine the exact point from which time runs for the taking of further steps or the entry of judgment in default of them.
Yes, so he's explaining there why there is why there are clear rules as to the manner in which service is effected. But at the end of the paragraph, he's referring to not just the purpose of service of bringing the claim to the attention of the defendant, but the other purposes of serving originating process, and we'll come on to see what those are. But on the facts of of our case, of course, we're not asking for the floodgates to open in terms of the alternative method of service that we're arguing for. And paragraph 17, assumption refers to the particular issues that may arise with electronic service and why it's important to follow the rules in relation to that. And again, on the facts of our case, we say none of this bites because we served electronically on the defendant's case holders. So, Lord Sumption is critical of Mr. Barton. See in particular at the end of paragraph 19 at letter D. He made an assumption as to service without checking the rules. Paragraph 20, he didn't accept that assumption was reasonable. And at the bottom of the page in 21, the problem was Mr. Barton made no attempt to serve in accordance with the rules. Just used a mode of service which he should have appreciated was not in accordance with.
Well, that does apply precisely to you, doesn't it?
Well, Lord, I wouldn't accept that we made no attempt to serve in accordance with the rules. We attempted but failed because of the error which we've identified.
Well, it depends. I mean, literally, the rules required you to serve on the notified designated on the designated email address, and you made no attempt to do so. You can make a broader point that you did attempt to make good service, but that's not quite the point being made here.
Well, we both attempted to. We both served the unsealed claim form at the right address, and which wasn't effective, and sought to serve the sealed claim form at the right address.
Well, why did you say you sought to when you didn't put it in the email?
Well, because as the email chain suggests,
I see. What you're saying, or there's no evidence to this effect, but you're saying the inference is that whoever sent that email, I forget her name, it can be inferred she was intending to serve the new proceedings address because she will have assumed that as the email chain had started with an email to that address, it was still there. Right. Okay.
I have to say, just so you understand, speaking for myself, I mean, that's simply an inference that can't be drawn without evidence. But you're asking us to make that inference, are you?
Well, I say that is what the email chain suggests, but I also say that we served the unsealed claim form at the right address, and you've seen what Mr. Potter says about that. There was a mistake made, but it wouldn't be right to say.
Nature. I see.
But it wouldn't be right to say we submit that there was no attempt to serve in accordance with the rules.
Well, perhaps at the end of the day, we're setting yourself a false problem. Although Lord Sumption, of all people, uses his word carefully, we're not nevertheless interpreting some statutory test. He hadn't in mind precisely these facts. What he was saying was slightly addressed to Mr. Barton, having deciding he would serve by email when the primary way was to serve personally or by post.
Yes, and without having checked what the rules said.
What do you make of the comments at the end of paragraph 21? As it were, the counterfactual cross-check with 763.
Yes. So I think that's what I was referring to earlier when I in relation to the fact that 7.6 had been relied on earlier in the proceedings. The obvious point in our case is that 7.6 is not applicable.
You say, and that's one of the issues we have to consider.
7.6 is a mechanism for extending the time period in 7.5.
Yeah, well, okay, we understand that, but you understand that there is an argument that you shouldn't read it literally, and that the test for any extension of time after time for service has expired has taken all reasonable steps to comply. If you lose on that point, which we haven't yet got to do, and the test for 7.6 is the test for extension of time, even if formally it's under Rule 3, has taken all reasonable steps to comply. It's hard to see how you could satisfy that. And it might be said that really what Lord Sumption is saying, or almost saying here, is once you've lost on that, it's hard to see how you can get there by another route, by validating an earlier ineffective attempt at service. Is that what he's saying?
Well, he's saying in the context of Mr. Barton's case that he can't see why Mr. Barton should succeed where he's failed under 7.6. But there are a number of points. First of all, Lord Sumption doesn't lay down 7.6 as one of the criteria in 7.6 as part of the test that needs to be satisfied when he's discussing the principles, and that wasn't.
Well, that's a fair point.
From in the previous.
And you could also say that it starts. I note in passing.
It's in passing, and he quite deliberately, we say, in laying down his factors to be considered, includes whether the claimant has taken reasonable steps as opposed to all reasonable steps, and it's only one factor.
Sorry, say that again. You say.
So it's subparagraph 4 on page 491. His first factor is whether the claimant has taken reasonable steps to effect service in accordance with the rules, and he's well aware that the criterion in 7.6 is all reasonable steps because he's set it out a few paragraphs earlier. And that, as I say, is one factor in the mix. It's not a hurdle which must be got over in every case, and certainly we would say not in a case where 7.6 isn't in play.
Right, thank you. Well, that answers the point I put to you.
And the real, I'm sorry, Milord. Sorry. The real criticism of Mr. Barton is in paragraph 23. Is the courting disaster. The person who courts disaster in this way, leaving it to the last day, can have only a very limited claim on the court's indulgence in an application under CPR 6.15. Now, either that simply doesn't read across at all to the 7-day period in judicial review, or if it does, well, we acted on the first day of the period. And when it comes to prejudice, later in that paragraph, where he refers to the prejudice to right hassle being palpable, because they'll be retrospectively deprived of an accrued limitation defence. He says, if Mr. Barton had been more diligent or Berrimans had been in any way responsible, this might not have counted for much. So although he is looking at the limitation defence, it's a relatively unimportant, or could be in a case where other factors were in play, it would be relatively unimportant, certainly not determinative. Well, Lord, we also rely on the judgment of Lord Briggs and Baroness Hale. It is the minority and reaches a different conclusion on the facts, but there is important guidance, we say, which is consistent with Lord Sumption's judgment, which this court ought to take into account. And paragraph 28, the other purposes of service. The second important purpose between letter E and F, to notify the recipient that the claim has not merely been formulated but actually commenced as against the relevant defendant. And you may have noticed from the defendant's skeleton argument, para 19.1, that the defendant says that that purpose was not achieved in this case. The defendant says that it was not provided with any formal confirmation that the claim had in fact been issued. That's just wrong.
You say Mr. Olson received
Mr. Olson and two others received the sealed claim form. So that purpose of service was fulfilled. And then in 29, and again consistent with Lord Sumption, the third purpose in relation to the specific email provisions was to ensure that there were appropriate arrangements in place so that the email actually reached the relevant person. And again, that purpose was satisfied in this case by sending the sealed claim form to the case holders. In paragraph 30, 1331, we say is also consistent with Lord Sumption's analysis. And the key point in para 30 is that where the three purposes of service are achieved, that is, Lord Briggs says, just above letter B, capable of being, at least prima facie, a good reason for validating service under Rule 6.15. Now, there may be other factors which outweigh that potentially good reason, as he goes on to explain. But we say consistent with the majority, and really it's a matter of common sense. When you're asking the court to validate an alternative mode of service, it must be relevant to what extent you've actually departed from the mode of service which was prescribed by the rules, and to what extent that made any practical difference to anybody. That must be important as a matter of common sense. And where the three purposes are fulfilled, as we say they are in this case, they were in this case, prima facie, that is capable of being a good reason.
What do you say the overlap, if any, is between 6.15 and 312A? Let's assume you're right, 7.6 isn't engaged. But where do you say even if a court would not extend time under 312A, it would still be appropriate to make an order under 615, and vice versa?
Yes, it may be. They are different rules. They bite on different things, and they bite on different events. In this case, we have the event on the 28th of April, which we're seeking to validate under 6.15, and the event on the 6th of May, in respect of which we're seeking an extension.
It's a bit of a mess, isn't it, in one sense? But you say technically it's possible to have different results.
It is possible. I accept there may well be some overlap in the factors which the court will consider, and you'll see from my submissions that I rely on some of those.
You made the point earlier that on although in the end Lord Sumption came down against the claimant and made that passing reference to 7.6, the fact is 7.6 had been decided against him. And Lord Sumption does not regard that in any sense a knockout blow.
No. So we say that really all the way down to paragraph 35 of the minority judgment, there is important guidance which is consistent and not inconsistent with Lord Sumption's analysis. And it's only when one gets to the application of individual factors to the facts of the case, and that's particularly paragraphs 39 and 40 and 41, that there is disagreement between the majority and the minority, and 40 in particular is disagreement on the limitation point. And Lord Briggs describes the limitation defence in the Barton case as a windfall, in the well-established sense from the personal injury cases, and that is something that we say about a limitation defence in this case. I'll need to
you're
come back
stuck
to
with
prejudice.
but you can't. Well, it doesn't help us to know that Lord Briggs disagreed on that point. It's clear he did disagree, and he knows he did because he says in respectful disagreement with Lord Sumption. So,
Well, he did, and I need to. I'll seek to reconcile the
yes, I'm beginning to get a little bit. We're going through this very laboriously. We're still on round one. We've been going for over a couple of hours. I think we do need to keep on the key points.
Indeed, Lord. So I'm finished with Barton. We say that the good reason in our case is that the method of service adopted by the claimant departed from the prescribed method only in the most technical and non-substantive respect. All conceivable purposes of service were achieved, and there is a public interest in this judicial review claim being determined. And we say that there were no factors of sufficient weight to displace that good reason. I then come to the reasoning of the judge, and that is compressed into a single paragraph, paragraph 64 of the judgment.
Hang on 1 second. Yes.
I say it's a single paragraph. In 65, she says that she's weighed up the factors and gives her decision. But in 64, having identified two factors which are against the claimant and one which is neutral, there's nothing really left to balance. So 64. She says it is clear that the claimant did not take reasonable steps to effect.
As I've understood it, the structure of para 64 is to apply Lord Sumption's three factors, which will normally be determinative, though in different weights. It's the factors in that paragraph.
Yes.
That's what she's
Yes.
doing here. Yeah.
Absolutely. So first one, reasonable steps. She says it's clear claimant did not take reasonable steps. Didn't use the designated email address for the sealed claim form, and she says the claimant did not take any step to serve the sealed claim form by the specified method within the stipulated period set out in 54.7. And I know we've had a debate about that sentence already. We say that the judge's approach here and up to the end of the sentence that ends 54.7 is the wrong approach, which effectively disabled her from considering the significance of the departure from the authorised method.
Why?
Because she regards it as conclusive that the authorised method was not used.
No. She goes on to consider the other factor.
I'm sorry, in relation to this factor, my lady. Sorry, I'll come on to the other factors. But in relation to this factor, the beginning and end of it is you didn't use the right method. And we say that
Well, not you didn't try to use the right method.
you didn't.
I mean, suppose, for example, you had put in your recordings, whatever it is, but had misspelt it.
Well, then we wouldn't have used the right method.
No, well, but you would have made. It could be argued that you'd use reasonable steps to effect service. Of course, in a sense, it's unreasonable to mistype or to leave out a dot or whatever it would be. But it's still, you will at least have tried. And here, her point, you may still say it's wrong, but her point is you didn't even try.
I think it's a point in your favour in some ways, isn't it? That if it suggested that you'd have been in a stronger position if you had failed to email, but because of a mistyping rather than not typing it at all, it shows what a game of forfeits we're engaged in.
Well, it does, my lord. I adopt that, but it also, in my submission, demonstrates that what is important under this, one of the important matters under this factor, is to what extent did you depart from the authorised method? What difference did it?
To some extent,
make?
it's unfortunate, I have to say, that there is no explanation given as to what actually happened. And, for example, we have the certificate of service, in which it very definitively says it was sent to these 3 email addresses, which were the ones we were notified of. And there's no explanation as to why it is that conclusion came to be reached, and whether that was a misunderstanding or whether it was thought that was good enough. Certainly it seems to be the case that whoever was dealing with this did not think it was necessary to serve new proceedings, not that they forgot to do it. Or failed, or failed to press the right button to insert the right email address.
Well, I think I've made my submission as far as I can on
But
that.
just so I understand your first point, you say that she simply concludes didn't take reasonable steps and erred because she did not assess the extent of the failure.
Yes, she didn't consider the extent and significance of the departure from the authorised.
Well, she's given. Forgive me for interrupting, but she's given no consideration at all to the fact that there had been a previous chains of correspondence in the course of which it had been made plain that Mr. Olson was dealing with the matter, and that he'd asked for the emails to be copied to him and the other members of the team, and that the service on the new proceedings address might well reasonably be assumed to have been a mere technical route through to them being received by that team. And she's not taken any of that into account. She just simply said, it's new proceedings or nothing. I ignore anything else that surrounded that.
Well, absolutely. I'm sorry. That's what I was trying.
It's also ignored what happened afterwards, which was that Mr. Olson had further correspondence about the action, refers to the possibility of being stayed, refers to the fact there was a council team in place, and overall, she doesn't say, which it seems to me, I for my part readily accept, that this is the most extraordinarily technical point to be taking.
Yes, and my lord, absolutely. That encapsulates my submission. I'm grateful. What her approach amounts to is you took no relevant steps at all.
Well, she seems to be equating not putting new proceedings in the email heading with not being entitled to serve by email, which is the Barton situation. And I'd have thought you would be submitting that it's a different order of things. Serving by email is a method of service, and the method used there was not permitted. Here, service by email was expressly permitted and indeed encouraged, and a number of email addresses had been given which were used. It's not here a failure to use failing to use the incorrect method. It is a very, very technical omission in using that method to include the specified email address as well as the copies. And isn't that really what you're saying here?
Yes, absolutely, my lord. It is, and it is. It's a thread that runs throughout the reasoning in para 64. Is that there is no account whatsoever taken of any of the factors which my lord has just put to me.
It's didn't serve new proceedings, so that factors against you.
That's it.
No balance, no checks, no analysis, no nothing. Yeah, well, that's the point there, isn't it?
And then, second reason, it is common ground that the defendant was aware of the contents of the claim form within the prescribed time limit, but satisfying that criterion alone is not sufficient to justify the exercise of 6.15. Well, she's driven to accept that the defendant was aware of the claim form, but again, that shouldn't be the end of the matter. What is significant, we see from the authorities, is how the defendant became aware of the contents of the claim form. And here,
and they'd asked to be copied in on it, so they not only were aware, but had wanted to become aware at the same time as it was served on their proceeding.
yes, and they were aware through at least an attempt at formal service.
Yes. And already had a counsel team lined up to deal with these actions, including this one. And she doesn't seem to have taken into account any of those factors.
Exactly. No reference to fulfilment of the various purposes of service, as in both the majority and minority judgments in Barton. And on prejudice, then, this was a significant factor for the judge. She rejects the claimant's argument that the defendant wouldn't suffer prejudice. That was because that was the argument that relevant prejudice was and must be in relation to the misservice. What did the defendant lose as a result of that error? And she relies on the defendant suffering prejudice because it would be deprived of any.
Yeah, well, okay, we know what she says. You must tell her why it's wrong.
So we say that even in an ordinary civil case, the fact that limitation has expired should not have overriding significance. And that's the point I showed you from Lord Sumption's judgment in Barton, that the whole point of 6.15 in the first place was to allow claims to continue where limitation had expired, of which Abella was one case. We say that the relevance of limitation should be approached differently in judicial review. First of all, because of the shorter limitation periods, 30 days and then 7 days.
Well, that's a double-edged sword, isn't it?
Well,
because you can equally say that there are shorter periods for good reason.
But it does mean that you've essentially got one shot and one shot only at service, because you will not have the opportunity to rectify any difficulties before.
All the more reason why you'd expect people to get it right.
But look, in contrast with the ordinary civil position where you have a generous period for service, and you can generally rectify any problems if you act early enough.
Well, forgive me, you keep making that submission, but we commonly come across it, particularly in commercial cases where you're trying to serve parties overseas, often through different regimes, that it's very difficult to serve multiple defendants in multiple jurisdictions with claim forms within 6 months. And certainly sitting in the commercial court, one is almost every day of the week asked to consider extending the validity of claim forms to reflect the fact that parties have not been able to serve parties overseas within 6 months. And I'm afraid I just don't accept that in civil proceedings generally it is necessarily the case that you've got lots of time to serve. And you may well often be up against the wire. And what sensible parties do in that situation is they come to court and ask for extension of time.
Whether or not there is a limitation defence in a judicial review is a more nuanced question in public law, we say, than in civil law, because of the general discretion to extend the time limit in CPR 54.5. The judge relied on the defendant's prejudice through being deprived of any limitation defence, but without going into any detail or weighing in.
Right, but it may be more nuanced, but it's real. You bring forget 30 days, an ordinary JR more than 3 months after the act of which you're complaining, you know you are in dead trouble. You may, nevertheless, persuade the court to extend time, but it's not in any way relaxed. On the contrary, all the dicta are, sometimes the dicta say even 3 months isn't a real time limit. It says promptly. So she was surely right to say that there is a prejudice because they could have had a strong argument. Who knows how it would have proceeded if she had allowed service and then a point had been taken that it was out of time. Sorry, if she's not a, you know what I mean, sorry. If there had an issue had arisen about it. But it couldn't be assumed that they would be given an extension. And they've lost that very substantial chance.
No, Lord, I agree. It couldn't be assumed that they wouldn't have a limitation defence, but equally it couldn't be assumed that they would have a limitation defence.
No, but when you're exercising your discretion, you're entitled to say, I can't go into that, but I attach real weight to the fact you're deprived of the realistic chance of developing of advancing a limitation defence. Isn't that a perfectly proper thing for her to say? That's why she very carefully said any limitation defence.
Well, she said it in few words, and it's far from clear.
Well, she maybe maybe a good or maybe a bad thing to be condensed, but it's very clear in this entire section. She had all the points on board, didn't she? If you go back to paragraph 54, points that you've made to us very helpfully this morning were all noted and acknowledged by her. Paragraph 54 and 55. Is there any error of law that you can identify in her analysis of the authorities and the principles from the cases?
Well, my lady, her account of the principles suffers from the same shortcomings as her application of the principles in paragraph 64,
right.
and that shortcoming is the failure to take into account the significance of the departure from the authorised method.
I understand that's your submission, but in terms of her analysis or comments of, has she missed out any relevant bits of the authorities from your perspective? She includes Lord Briggs at paragraphs 28 and 31. Do you have any complaint about her summary of the law and the principles?
Well, yes.
Not her application of the principles, but her summary of the law and the principles.
Yes. So paragraph 59(3),
Yes.
and consistent with what I've just said, that is right so far as it goes, but it doesn't go on to say it also matters whether the how the defendant became aware of the existence and content of the claim form, and to what extent the manner in which the defendant became aware departed from the authorised method. So these, and that's an example of a principle which is right so far as it goes, but it's incomplete.
What principle do you say is missing?
Well, the point that I was making there was that it's not simply has the defendant become aware, but how did the defendant become aware? So just to give you a reference.
Well, that's very what do you mean has it become or how? Can you be more precise?
Yes. So as Mr. Justice Popperwell says in the Goldass case, the strength of the factor. This is page 470, paragraph 49(3). The strength.
Sorry,
of,
repeat the reference, please.
Page 470, paragraph 49(3). The most important function of service is to ensure that the content of the document served is brought to the attention of the defendant, see Abella 37. The strength of this factor will depend upon the circumstances in which such knowledge is gained. It will be strongest where it has occurred through what the defendant knows to be an attempt at formal service. It may be weak or even non-existent, where the contents of the claim form become known through other means.
So what is missing, as a matter of principle, is that the strength of the point will depend on the circumstances in which knowledge is gained.
Well, that's what is missing from the point made in Roman 3, and the effect of leaving out that qualification, that addition, is to leave out.
It's on a very general level. Your point is a much more specific point, isn't it? That they knew not only what the case was and what the claim was, but they knew that it had been included in a formal claim form issued that day. That's the point, isn't it?
Yes. They became fully aware that the claim had been issued on the day that it was issued, and more quickly than they would have done had we only sent it to new proceedings.
Well, I think the point is that there was absolutely no difference to what they would have known.
Yes.
The way you did it, than if you had sent it to new proceedings.
Yes. And well, I'm sorry about being on a more general level. I was asked about the principles, but the fundamental point is that the strength of our case, as we submit to the judge and we submit to this court, is in the technicality of what was not done in terms of its effect. No practical effect whatsoever. And the judge's approach, both to the law and then in setting out the law and in applying the law, is to leave all of that out of account.
I suppose what Mr. Olsen didn't know was that you'd serve proceedings.
No.
Can I suggest we have to rise now? We'll take up any remaining points with you. I am concerned about time. I don't criticise, you've been very thorough, but we do need a bit of focus because there's a lot still to get through. We haven't got to round 2, all the respondents' notice points. So can you...
I can be back for 2.
Can you...
2 if you try. Well,
Well, my lady says that she will attempt to be back by 2, make it a bit easier. But nevertheless, my stricture stands. Be here by 2. If we're a bit late, you'll know why.